A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a pivotal ruling that has captured the attention of land rights advocates and outdoor enthusiasts alike, the Supreme Court has confirmed that wild camping is permitted on Dartmoor, overturning a challenge from a wealthy landowner who sought to restrict this right. The case, which has been closely monitored across the country, centered on the interpretation of the Dartmoor Commons Act 1985, which enshrines the public's right to access the commons for open-air recreation. This decision marks a significant moment for outdoor recreation in England, as Dartmoor remains the only location where such rights are legally protected without the need for landowner permission. The legal battle began when Alexander Darwall, a multi-millionaire hedge fund manager and one of Dartmoor's largest landowners, initiated proceedings against the Dartmoor National Park Authority (DNPA). In an effort to prevent wild camping on his 4,000-acre Blatchford estate, Darwall argued that the presence of campers posed risks to his livestock and hindered his conservation efforts. He claimed that the law did not allow him to exclude campers from his land, which he believed had detrimental effects on the environment. Despite Darwall's claims, the DNPA maintained that wild camping does not harm the environment and is a vital aspect of Dartmoor's heritage. The authorities' defense was bolstered by the public's growing support for the right to roam, with thousands of campers flocking to Dartmoor to advocate for their right to camp freely. The case escalated through the courts, with the High Court initially siding with Darwall in 2023. However, the Court of Appeal later ruled in favor of the DNPA, affirming that the law does indeed allow for wild camping on Dartmoor Commons. This prompted Darwall to escalate the matter to the Supreme Court, where the judges were tasked with interpreting the meaning of open-air recreation as outlined in the Dartmoor Commons Act. Darwall's legal team sought a narrow interpretation of the term, arguing that it should only encompass walking and horseback riding. In a surprising twist, they even contended that activities such as picnicking should not be classified as open-air recreation. However, experts warned that agreeing with this restrictive interpretation could have far-reaching implications, potentially prohibiting various forms of outdoor enjoyment, including rock climbing and bird watching. Ultimately, the Supreme Court unanimously ruled that camping is indeed a form of open-air recreation, and that the public has the right to access the Dartmoor Commons for the purpose of camping, as long as they enter on foot or horseback. The judges emphasized that the law does not require individuals to remain on foot or horseback while camping, thus allowing for a broader understanding of recreational activities. Kevin Bishop, CEO of Dartmoor National Park, expressed his delight at the ruling, stating that it represents a victory for public access to nature and for future generations. He reiterated the importance of responsible camping and respecting both the land and its owners. The ruling has sparked renewed calls for a nationwide right to roam in England, with campaigners urging the Labour Party to revive plans to legalize wild camping across the country. Guy Shrubsole from the Right to Roam campaign highlighted the need for legislative action to protect and expand public access to nature beyond Dartmoor. MP Caroline Voden, representing South Devon, celebrated the ruling as a validation of the public's right to enjoy nature. She expressed hope that the Labour government would take decisive action to extend wild camping rights across the UK. Voden remarked, "The stars are for everyone, and access to nature is not just a luxury, but a fundamental necessity for a happy, healthy life." The Supreme Court's decision reaffirms the historical significance of Dartmoor as a place for public recreation and highlights the ongoing struggle for land rights and access to nature in England. As the nation reflects on this landmark ruling, it is clear that the conversation around public access to the countryside is far from over, with advocates pushing for broader rights to roam and enjoy the great outdoors. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.